I want to talk to you today about a situation that many of our clients have faced over the years. We have a lot of collision type cases where the person, say, was out drinking for the night, or perhaps they had consumed a drug such as cocaine or marijuana earlier in the day, and an accident ensues, and maybe there's injuries, maybe they're not, but they're taken to the hospital ultimately, and maybe they're unconscious, maybe they're not able to give a breath sample due to injuries, for example. The police want to investigate for impaired driving. What the police will do in this situation, if they have reasonable and probable grounds that the person has alcohol in their system that caused the accident or caused impairment, or that they have drugs in their system, but they can't, for example, provide a breath sample due to, say, broken ribs, they're going to, first of all, obviously the people at emergency, the doctors are going to take blood tests. The police are going to get a search warrant for those blood tests. And those results are then going to go to the Center of Forensic Sciences. The Center of Forensic Sciences, it's probably going to take, in my experience, about 2 to 4 months for those results to come back. And in the meantime, as the person's not charged, but they're on pins and needles waiting for the results, you go, geez, I only had 3 drinks earlier in the night. Was that out of my system? Am I going to blow over? Geez, I had that cocaine at 12 today. The accident's 8. Maybe it's out of my system. Maybe it's not. So the client asks, well, what do I do in the interim? I say, look, say nothing, do nothing. Do not talk to anyone. Let's hope the results show that it was clear or very low at that point and they can't prove impairment. So what happens then, it comes back and we get the results, the police get the results, and the person's over the legal limit. For example, of blood alcohol, 80 milligrams of alcohol in 100 milliliters of blood or over. So they're going to charge them then with impaired driving and blowing over, and then we're going to see if there's any defenses to that. So those charges aren't going to come for about 4 months, 2 months. Obviously, we hope that they were under the legal limit. And the same thing for drugs. If there's drugs shown in your bloodstream at the time of the accident, the Center of Forensic Science is going to state the amount, whether it's THC, whether it's cannabis, obviously, whether it's cocaine or opiates or oxys. These can cause impairment at certain levels. We hope, obviously, the level's low. We hope there was nothing in your system, but you're going to get charged. They're going to get an opinion from a Center of Forensic Sciences toxicologist, say you're impaired. And then we're going to see if you can defend the charge. So that's about a 2 to 4 month process. It's a pins and needles process. You got to just shut up in the interim, not talk to anyone, and hope the charge just goes away. But it's a common situation. And you know, we can often challenge those search warrants. We've been successful in that. Sometimes the police don't do valid search warrants. Sometimes they shouldn't have taken blood, for example. Maybe they could have done a breath, but they decided to take blood in that situation. Maybe they didn't, if you were conscious, maybe they didn't do your rights to counsel properly. So there's all sorts of defenses to these things. We win a lot of hospital type cases on DUI, but that's a bit of a nutshell discussion of taking blood or samples at the hospital pursuant to search warrants in a DUI type case. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.